Okay, we're on the record in cause number 325700. Case is Style of State of Texas versus Jordan Thomas Patrizzi. Mr. Patrizzi, is that your full name?
Yes, sir.
Okay, Mr. Patrizzi, how are you doing?
Been better.
Okay, your attorney announced earlier that you have a medical condition that resulted from an injury?
He had a fall in January of 2017, Your Honor, and it has affected his balance. And he is under a doctor's care, and that's the physical symptoms that the court saw this morning are from that, Your Honor.
Okay, I need to inquire a little more into that. Is it now pursuant to the Article 1.24, all trials and proceedings are in Texas under that code provision should be public. However, that can be, let's see, it can be closed pursuant to Lilly versus State 365, 321, if there is it can be outweighed by his competing rights or interests, such as interest in security, preventing disclosure of non-public information, or ensuring that the defendants receive a fair trial. Mr. Crenshaw, you still want to go forward with this as a public hearing, or do you desire
You
to?
don't want the judge to ask everyone with the courtroom duty to ask you some questions about your competency. No, we're fine with the court proceeding.
Okay, so it'll still be public. Mr. Patrizzi, let me do this here. Do you understand what you've been charged with?
Yes.
And have you been able to, do you understand the consequences of this offense?
Yes.
What can happen, and what's the punishment range?
Well, I don't know necessarily the jail time, but 1 year probation, also mandatory interlock device on my vehicle, AA meetings twice a
I think that's probably your plea bargain, but I'm just asking you, what's like the range of punishment, for example, do you know?
I don't know the exact number of days of jail time.
I told him, Your Honor, that it was a Class A misdemeanor that they were waiving the enhancement on, and it was going to be a Class B misdemeanor, and that if he violated his probation, he faced up to the full term. It's obviously 180 days, but I do not think my client knows the number 180 days.
Okay, well, okay, I was just trying to inquire, see what, did he have understanding of the charges against him and the potential consequences of the pending criminal proceeding?
His ailment is physical, Your Honor.
I understand, we're trying to get there. Okay. Now, have you been able to disclose pertinent facts to your attorney about what happened in this case? You told him what happened?
Yes, sir.
From what you, I'm not going to ask you to tell me what happened.
Right.
But you were able to
Yes.
disclose, and Mr. Crenshaw, your client has been able to disclose pertinent facts to you, facts and events in his state of mind?
Yes, Your Honor.
Now, Mr. Patrizzi, I know that your attorney has advised and counseled you. Have y'all been able to engage in a reasonable choice of legal strategies and options? Y'all talked about that?
Yes.
Okay. Now, have you been diagnosed with any mental illness or an intellectual disability?
No.
You haven't? Okay. Okay. And are you taking any psychiatric or other medication?
I was diagnosed with epilepsy and
Okay.
so I take seizure medication for that.
Okay, okay, but you don't, do you take any medicine that is necessary for you to maintain your competency?
No.
Okay. Okay. Okay, the court also will observe that his appearance and courtroom demeanor and ability to participate in the proceedings are satisfactory. Okay. We go forward.
Thank you, Your Honor.
Okay. And before we go forward, just let me put this on the record. The court has conducted an informal inquiry to inquire whether there is some evidence from any source that would support a finding that the defendant may be incompetent to stand trial. The court considered the factors that are in Article 46B.024, and the court is of the opinion that after conducting the informal inquiry that the defendant is incompetent, that there is no evidence from any source that would support a finding that the defendant may be incompetent to stand trial. Okay. Oh, thank you. I've been looking.
Good signature.
We ought to still on the record in cause number 325700. The case is styled the state of Texas versus Jordan Thomas Patrizzi. We have Mr. Patrizzi in court. Mr. Patrizzi, would you please raise your right hand? Mr. Patrizzi, do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
You may put your hand down. And how are you doing, Mr. Patrizzi?
Good.
That's good. Okay, Mr. Patrizzi, you're here represented by your attorney, Mr. Crenshaw. Mr. Crenshaw, how are you doing?
I'm fine, Your Honor. When my client called me this morning, he asked if we could get a wheelchair to get him in the courtroom, and I declined that, saying I didn't think that he needed it. In hindsight, I regret saying that, and I wish I would have got him a wheelchair, but he is doing fine, and we're ready to proceed, Your Honor.
Okay. Mr. Patrizzi, I have before me an information that alleges that on or about October 8th of 2019, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. It has been brought to the court's attention that the state is abandoning the enhancement paragraph. Is that correct?
That's correct, Your Honor.
Oh, so the state is abandoning the enhancement paragraph, Mr. Patrizzi. So what that basically means is that instead of you being charged with a Class A misdemeanor, you're being charged with a Class B misdemeanor. Okay. And the range of punishment for Class B misdemeanor DWI is confinement in jail for at least 72 hours, but not to exceed 180 days, and a fine not to exceed $2,000, or you could be given both such fine and confinement. Do you understand that?
Yes, sir.
Okay. Now, to the charge of the Class B misdemeanor offense of driving while intoxicated, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes.
Okay, Mr. Patrizzi, I have before me a document that is, let me do this here, state abandons. I'm just making a note on this document that the state is abandoning enhancement paragraph.
Thank you, Your Honor.
And I will be initialing it. Okay, now, Mr. Patrizzi, I have before me a document that is titled the misdemeanor plea admonishments. It is also labeled State's Exhibit Number 1. Now, you note here that some writing here that I states that the state is abandoning enhancement paragraph, and I put my initials there. Do you see that?
Yes, sir.
Now, do you recognize this document?
Yes.
Now, on page 2 of this same document, there are a set of initials on the line there's a set of initials on the line that says guilty. Are these your initials?
Yes.
And on the next page of this document, there's a signature. This signature is above the line that says defendant. Is that your signature?
Yes.
On the next document, which is the trial court certification of defendant's right of appeal, do you recognize this document?
Yes.
Is that your signature above the line that says defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case. You have no right of appeal. Do you understand that?
Right.
The second box states that you're waiving, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
I have another document here. This document is titled the discovery certification. Do you recognize this document?
Yes, sir.
Is that your signature on the line that's titled defendant?
Uh-huh. Yes.
Now, prior to signing and initialing all of these documents that I've just mentioned, did your attorney go over these documents with you?
Yes, he did.
And did you read and understand everything in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer State's Exhibit Number 1?
Yes, Your Honor.
No
Any
objection,
objection?
Your Honor.
No objection. State's Exhibit Number 1 will be admitted. Now, Mr. Crenshaw, you advised in counsel, Mr. Patrizzi, and the court has made an informal inquiry regarding Mr. Patrizzi's competence to stand trial. Is there any evidence that he's mentally incompetent to stand trial?
No, Your Honor.
Mr. Patrizzi, your attorney, Mr. Crenshaw, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Patrizzi, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor. It's for 1 year deferred probation, a $1,000 fine, 80 hours community service, drug and alcohol assessment, DWI education class, an interlock device, and AA meetings 2 times a week.
Okay, hold on a minute. Now, Mr. Patrizzi, let me do this.
Is the court looking at the offense date?
Well, I know the office date is after September 1st, so I mean, I know the statute is in effect. The other thing is the blood test. Yeah. According to section 42A.102, subsection 1B2. Yeah. He has this is under the DWI statute, and his blood concentration level is defined under 4901 was 0.15 or higher or more. So I don't think he qualifies for a deferred.
Well, since our position, Judge, is that since the state waived that it's not.
Well, but he's still charged under it. I mean, you waived it, but he's still charged under 490. Yeah. I think it's still, 49. Where is it? 4904. 49. Yeah, it's still under 4904. They say 4904 through or 4906. I mean, and at the time of the offense, the defendant's alcohol concentration as defined was 0.15 or more. So, I mean, the way that reads, it was at the time of the offense.
Well, if the state abandons that though.
They're
court-
abandoning it, they reduce it, but he still had it. That doesn't, his blood test is still there. That, I'm looking at the information, that doesn't change his, I mean, we may have to do some research on that, but I'm just saying the way I'm reading it. I can give you some time to maybe do some research on it, but from what I'm reading, it seems like is at the time of the offense, his blood alcohol was down. Even though they abandoned it, it's still, that doesn't change the fact that them abandoning the enhancement paragraph does not change the fact that his blood test was still 0.15 or more.
Well, by that logic, Your Honor, if a defendant was enhanced 25 to life and the state waived an enhancement paragraph and proceeded with a plea less than 25 years, the court doesn't say, well, he's been to prison twice, so the minimum is
No,
going to be.
I'm just
25
saying, I'm just using this. Yeah, I'll give you a chance to, as I said, give us some, we can brief the subject, but because right now I don't think I'll be comfortable in going ahead just with the deferred until I get some better clearance from the way it's written. It seems as though, I mean, they wrote it like that.
Well, I think they wrote it like that because on a 0.15 or more
Yeah.
Class A, they did not want it deferred.
Yeah.
And so when you proceed on a Class B, say he was intoxicated based upon drugs and not alcohol, then
The
and the
defendant-
state's abandoned it. I don't know why the court wants to consider it if the state's abandoned.
Well, no, I'm just saying right now, I'm just saying I'm not comfortable. I just need to get we just have to research the issue on this here, okay? I mean, I know we haven't been doing deferreds for a long time, but that's an issue that needs to be researched before the court is comfortable in just going ahead and putting him on deferred. That's what the court is saying. Okay. So at this time, we can allow him to withdraw his plea, and we can just research the matter. That's what we can do. Because if we go forward now, we come back and find out that he wasn't able to get it, that he shouldn't have got it, we can't go back and undo that. So it's, the abundance of caution, it would be better to, put the brakes on right now, research, and then once we get get the answer on it to that question, then we'll be able to go forward.
Okay. So.
I mean, we can reset it 30 days. We'll have a chance to research the issue. Okay. Okay, give him a chance to, we'll just line the
Can
withdrawal.
we leave the plea as is, Judge, and only withdraw if the court makes a final determination not to accept the plea?
I'm not gonna, no, we just won't go forward. We'll just won't do it, and then we'll come back and do it.
Okay, so
Okay.
we're withdrawing everything?
Right,
Okay.
yeah. I mean, that's his choice. He can withdraw, because I'm saying right now, if you go forward, I'm not gonna go forward on the deferred, accept the deferred.
I need to remove another one.
Okay,
All right.
okay. Okay.
Okay. I won't put you back. We're gonna go right back here where you
Okay. Troy Door? Is that?
Okay. Very well.
You got it, thank you.
You have a prosecutor?
Who is this now?
Troy Door?
Dora?
Dore? It's Dore?
Yes, sir.
Okay. We're on the record in cause number 320439, State of Texas versus Troy Joseph Dore. We have Mr. Dore. Mr. Dore, is that your full name?
Yes, sir.
Mr. Dore, would you please raise your right hand? Mr. Dore, do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? You may put your hand down. Mr. Dore, how are you doing? I'm doing fine. Thanks for asking. Mr. Dore, you're here with your attorney, Mr. Bruce Smith. Mr. Smith, how are you doing?
Fine.
Okay, Mr. Dore, I have before me information that alleges that on or about August 19 of 2018, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault family violence. Mr. Dore, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Dore, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Correct.
Mr. Dore, I have before me a document that is titled Misdemeanor Plea Admonishments, which is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Dore, are these your initials on the line
That's correct.
that's titled no contingent, which means no contest?
Right.
And on page 3 of this same document, Mr. Dore, is that your signature above the line that says defendant?
It is.
And also, Mr. Dore, I have before me a document that is titled Trial Court Certification of Defendant's Right of Appeal. You recognize this document?
Yes, sir.
Is that your signature above this document, above the line that says defendant?
Yes, sir.
There are 2 boxes checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Correct.
I also have before me a document that is titled the Discovery Certification. Do you recognize this document?
Yes, sir.
And is that your signature on the second line of this document?
Yes, sir.
Now, Mr. Dore, prior to signing and initialing all of these documents that I've just mentioned, did your attorney go over these documents with you?
He did.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer State's Exhibit Number 1?
I'd like to offer State's Exhibit 2, the probable cause affidavit.
Any objections?
No, Judge.
No objections. State's Exhibits 1 and 2 are admitted. Mr. Smith, you've advised and counseled Mr. Dore. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Dore, your attorney, Mr. Smith, has advised and counseled you Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Dore, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state. Do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
It's for 90 days, prorated over 2 years, a $500 fine, 80 hours community service, BIP, and no contact with Heather Dore.
Dore, the state is offering that you serve 90 days in the Jefferson County Jail. However, you will not have to serve any time in jail because you'll be placed on probation for 2 years. During the 2-year probationary period, you'll be required to pay a fine of $500 plus court costs of $412, which comes to a total of $912. Mr. Dore, you will also be required to pay $60 in probation fees. You'll also be required $60 in probation fees each month. And you'll be required to pay $50 each month in a urinalysis fee. Your total monthly installments will be $115. Mr. Dore, would you be able to pay the $115 per month?
Yes, sir.
Now, Mr. Dore, you'll also be required to perform 80 hours of community service. You will have to pay a fine of $100 to a family violence center in Jefferson County. You will also be required to participate and complete the BIP program, and you cannot have any contact with Heather Dore. Now, you'll also be required to adhere to the other standard terms and conditions of this probation. Mr. Dore, do you understand the state's offer?
Yes, sir.
And do you accept the state's offer?
I do.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
Okay, Mr. Dore, I'll follow the plea bargain agreement that you've entered into with the state. Mr. Dore, there's an X next to your attorney. You're gonna stand on that X. You're gonna follow the instructions from our court clerk. And once you finish with those instructions, you'll be free to go.
Your Honor,
And you have a,
I need to address,
oh,
the paperwork is showing that he has a warrant for failure to appear on this case. However, on that date, he came, when I was leaving,
About 10 minutes later.
he was about 10 minutes late and he came back up here. I had to go to another court and I appeared in front of you with him on Zoom.
but this,
Yes, Your Honor.
what date was it?
And for some reason, and you even had him sign a document saying that he cannot be around.
That was the.
Pull that,
Yeah, the bond.
no, I didn't have him sign anything that he
No,
came.
There was some paperwork done, that exchange or something of that nature.
Order said
Was it-
bond conditions.
I think the deal, yeah.
A bond condition, that's what it is.
What day was that?
The 7th, I think it was May the 7th.
So you're saying his bond was
Saying
forfeited?
that I wasn't here.
No,
He was like 10 minutes late and he came back up.
no, but you're saying that he was here.
Well, he wasn't here at the time. See, I was here and I announced to the court that I have not seen him. I went downstairs. I saw him coming in. I told him to immediately come up here. I had to run, and I think it's my recollection. I came back and appeared on Zoom.
April, May.
Is it possible that it was on the other case that? Mr.
I don't
Dore has
know.
Pending? I believe that might be what it, looking in AS 400, I believe that the hours that is for the other assault case that is pending.
Okay.
What number does the assault have on it?
I have, I know I did. You just brought this up. I don't, they're looking at it. They're trying to look it up now. So he has,
I could be mixing it up. That's just what my recollection is.
okay, well, hold on a second. We have someone from the county clerk's office.
Whose signature is that? Who is that?
I don't know. That's secretary. Signing as an attorney.
Sign as an attorney.
A pro se, that's not your signature.
For that day. Is that your colleague, Mr. Smith?
No, she can be able to sign. will she?
Well, what I'm worried about is my personal signature.
Verified if this is active.
Okay, well, you just have to sit in the jury box, I mean, until we,
This is on this case here. I don't know.
So we don't know whose signature that was?
I have no idea.
just have, well, let her finish here and just have a seat in the jury box so we can, sort through this. Okay. So we have, they trying to check the computers and
What other
everything.
case you talking?
There's another pending, I don't have a copy of it.
Ma'am, we can't hear you.
Here it is. I don't think he's gonna qualify. So.
Yeah, ma'am, we can't hear you.
Hello?
Yeah, you might have to come in here. We can't.
Can you hear me now?
Oh, that's Miss Selman. Miss Selman, just put your,
That's my client, Your Honor.
okay, just make sure, yeah, you can put your mic on mute right now. We're trying to finalize a plea right now. Who's the prosecutor? Who's the prosecutor on this? Is
Yeah.
Judge, we have a bond forfeiture docket at 11 as well. I was just informed.
okay, well, okay. Just hold on. We're handling another matter in here. We're back on the record in cause number 323-380.
I'm printing it for you.
And the case is styled, the state of Texas versus Rudolph Osorio. Mr. Osorio earlier pled guilty in this offense, well, to this offense. And Mr. Osorio acknowledged that State's Exhibit Number 1, the discovery certification, and trial court certification of defendant's right of appeal. He acknowledged that his attorney went over those documents with him. He read those documents. He understood everything in those documents. Everything in those documents is true and correct to the best of his knowledge. And Mr. Osorio, the state found that, well, the state accepted his plea of guilty. The state found that he was, well, the state or the court found that he was mentally competent to stand trial. The court also found that his pleas and waivers were freely and voluntarily given. And the court also found that there was sufficient evidence to find him guilty beyond a reasonable doubt. And the court also accepted his plea of guilty. Mr. Osorio, the state offered, made this offer to Mr. Osorio. Mr. Osorio accepted the offer, and the offer was that Mr. Osorio serve 180 days in jail. However, that will be probated for 1 year, and he was given a fine of $500 plus court costs of $407, which came to a total of $907. He also was required to pay the Jefferson County DWI education class and initial evaluation fee of $125. And should a further evaluation be needed, he was to pay $50. And the total monthly installments that he was required to pay was $160. The court inquired as to whether or not he can pay that amount, and then the court allowed him to take some time to fill out an affidavit with his financial information on it. The court has received this affidavit with Mr. Osorio information. Mr. Osorio, do you recognize this document?
Yes, sir. I do.
And did you did you fill out
Yes,
this
sir.
document?
I will.
And is everything in this document true and correct to the
It is,
best
Your
of
Honor.
your knowledge?
Yes, sir.
Okay. Now, Mr. Osorio, looking at this document, it shows that your take home is about $1,700 a month. And when we add your bills or your expenses, it comes to an amount of $970. So Mr. Osorio, the court is not going to find that you're indigent at this time. And just for the record, Mr. Osorio also stated to the court that he worked 50 hours a week and he was making $15 per hour. Is that
Yes, sir, Your
correct?
Honor.
Okay. So, Mr. Osorio, the court is not going to find that you're indigent at this time based on the information that you have provided to the court.
Yes, sir, Your Honor.
Okay, so get back to this, Mr. Osorio. It looks like you have some monies left over to pay, and
Yes,
your
sir.
fee
Yes,
is
sir.
$160 per month. Will you be able to pay that?
Yes, sir.
Okay.
Yes, sir.
Now, Mr. Osorio, do you understand the state's offer?
Yes, sir, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes, sir, Your Honor.
And do you accept the state's offer?
Yes, sir, Your Honor.
Okay, Mr. Osorio, I'll follow the plea bargain agreement that you have entered into with the state, Mr. Osorio, that is X next to your attorney. Please stand on that X.
Yes, sir.
You're gonna follow the direction of our court coordinator.
Yes, sir, Your Honor.
What are we changing?
Nothing,
Nothing?
nothing. No, he didn't qualify.
Okay, so,
That stays the same.
same, the same, everything.
Yes.
Your Honor, could we approach?
Oh, okay, hold on a minute. So, Mr. Osorio,
Yes, sir. Your
once
Honor.
you finish with the court
Yes, sir.
clerk, you'll be free to go and you have a blessed day.
Thank you.
And Mr. Rojas, you'll be free to go as well and you have a blessed
Thank
day.
you, Judge. You as well.
All right. Okay. Are we back on Mr.
Dore.
Dore? Mr. Dore, you come forward. Okay,
Your Honor, what I did tell you on the concerning him coming back up here and all that, that did happen, but it was on the case that we just pled.
okay,
What apparently talking about is the favor here is on a family assault charge that we knew nothing about. And had we known about this, I would not have gone forward this morning on this other case.
And I know about it either. I didn't know. I
was, no.
Okay. So,
So I'm asking the court to allow us to withdraw his plea of no contest, to give me time to investigate, because this allegedly happened back in April,
okay,
April the 18th, and apparently, and I know that he just told me that and quite frankly, the lady that is mentioned in here is in the court. And she's gone up to the DA's office to request charges be filed.
okay,
Just not filed,
okay.
yeah.
So at this time, that knowing about that case would affect your client's ability, your client's decision to
Yes, sir.
plead to this case. Okay, so at this time, the court is going to allow you to withdraw your plea.
Thank you.
Okay, so we still have a warrant out on him, right?
Yes, sir.
Right, okay, just follow the bill.
You have to make a bond and contact us.
Yes, yes. We'll be in recess. Court will be in recess.